You may be seated.
Welcome everyone to the final round of our 2025 residential Moot Court Intramural competition. This has been a few weeks in the making and we're so excited to be here now. So thankful to our traveling judges who have come here from various states. We have Justice McKenna, Associate Justice of the Hawaii Supreme Court, Justice Silver from the Nevada State Supreme Court, and we have Justice Timmer from the Arizona State Supreme Court. Before we begin, we would like to express our gratitude to you on behalf of Southwestern Law School and the entire Moot Court program for coming here. We have provided thank you gifts and we have made donations in each of your names to charities that are assisting fire victims from the horrific wildfires that affected victims in Los Angeles this past January. We have thank you cards and donation letters for each of you, so thank you so much.
Thank you.
Thank you.
McKenna, Justice Timmer,
Sorry, we switched it up on you.
and Justice Silver.
Thank you.
So thank you all for taking the time to come. We so appreciate it. With that being said, are we ready to proceed with the round?
We are.
You guys are just going to have to remember who I am because I can't make this stand up. I want my water. So. All right, thank you.
All right.
Good job, Jeremy. Good job.
All right. Good afternoon, competitors, Moot Court members, family members, staff, faculty, all part of the Southwestern community. Welcome to the final round of our intramural competition. At this time, I will go over some housekeeping items and some round procedures. Appellant, do you intend to reserve time for rebuttal?
Yes.
Great. Appellant, please be sure to request 1 minute of rebuttal from the Chief Judge at the beginning of your argument. This is the order you will argue today. Appellant will argue for 14 minutes. Appellee will then argue for 15 minutes. After that, appellant will have 1 minute for rebuttal. I will hold up time cards throughout your argument to let you know how much time you have left. Time cards are 10, 5, 1, and 0 minutes. As a reminder, you are expected to argue both issues, falsity and actual malice. With that, we are ready to proceed. I will now call the case to order. All rise. Oyez, oyez, oyez. The Ninth Circuit Court of Appeal is now in session. Chief Judge Silver presiding along with Associate Judges McKenna and Timmer. All persons having business before this honorable court are admonished to draw near and give their attention, for they shall be heard. God save the United States of America and this honorable court. The first case for argument today is Jet Weiss versus the Bear Network, Inc. Alexis Villatores for appellant and Wasal Esper for appellee. You may be seated.
Good afternoon, ladies and gentlemen, and thank you all for being here today. We are going to start with Weiss versus Bear Network, 25-0034. My understanding from appellant is you have a 1 minute rebuttal. Is that correct?
Yes, Your Honor.
Whenever you would like, you may address the podium and proceed. Thank you.
Good afternoon, Chief Justice, Associate Justices. My name is Alexis Villatores, and I represent the appellant, Jet Weiss. I'd like to reserve 1 minute of rebuttal at this time.
That will be the order.
Thank you. Preserving the truth is an interest that we ought to uphold. Allowing media companies to make a calculated falsehood and false portrayal of a person is simply not an interest we ought to uphold. This court should reverse the lower court's ruling for the following 2 reasons. First, there is a genuine issue of material fact that ought to be reserved for the jury to decide because the edited statements materially altered Wise's original statements. Second, TBN's profit motives, coupled with the intention to paint Wise in a version of him that simply does not exist, raises a genuine issue of material fact as to actual malice.
So counsel, isn't this case really identical to match letter, which is what the district court cited to in its order, and that we have exact footage filmed without alterations, without voiceovers, and like match letter, Mr. Weiss knew the camera was rolling 24/7. He knew it's rolling. And that's what he signed up to do. Doesn't the First Amendment protect the media's discretion to present stories in their own way because the editing process entails professional judgment, which is exactly what happened here?
Your Honor, I believe that this case is distinguishable from the Mockler case because the court there believed that the loyalty to the speaker's words in that moment were captured correctly. If you added the context in Mockler, it would not have changed that he ultimately was intempered, yelled, and said the words that he said. Yet here, if you were to have added that context, I'd argue there'd be a different effect on the mind of the reader, which I'd like to direct the court's attention to Price versus Stossel, decided in 2010 by the United States Court of Appeals for the Ninth Circuit, where there the court emphasized that loyalty to a speaker's words is much more important than even a reproduction of that speaker's words.
But one of the things, like of the Price case, and that was the case with the minister, correct? Where the minister made a quote about some accumulation of wealth and luxury goods, talking about a third person, but then it was really about they used it to be about himself, which was completely untrue. So you said in your first point that here you would show that there's a material alteration of what Mr. Wise said. But can you point to what is materially inaccurate? Because isn't that what we're looking for? Not so much alteration, because people can edit, correct?
Yes, Your Honor.
Yeah. So aren't we really looking to see, was he portrayed in some type of a negative personality trait? Isn't that pretty much the test?
Your Honor, we are not looking to see if the plaintiff was paid in a balanced or even a favorable light. We're simply asking the court to uphold the truth. And here, as in Price, the added context would reveal that this character that Price was portrayed as, the sermon he was given, this ultimate villain that simply did not exist, would have been proven false by the unedited footage. And we are not asking the court ultimately, Your Honor, to find that there is falsity. We believe that there is enough that a jury ought to decide whether falsity exists, which we believe it does. When you put those two footages on pages 40, transcripts on page 40 and 42 of the record respectively, the edited and unedited statements, I believe a jury would be able to decide.
Well, I mean, he did say, let's be honest, fame will get me what I want, correct?
Yes, Your Honor.
I take it from your briefs that you're saying that implies a negative connotation, but how is a court to be put in that position to decide that? It's like me being quoted to say, this is a dream come true. Why is that negative?
Your Honor, I'd like to emphasize that we are not asking the court to decide whether a negative portrayal of a plaintiff is enough. We are not arguing that. I'd like to answer your question by directing you to Masson versus New Yorker magazine, decided in 1991 by the Supreme Court of the United States, where the Supreme Court said that even if a plaintiff says every single word, as Wise admittedly did here in the edited statements, removed context can be materially altering to a speaker's intention. The intent behind Wise's words were the fact that he wanted to help the deaf community. That was the sole purpose for him being on the show, and that statement in its entirety was inseparable, which relates to Wise because it created a version of Wise, this selfish person that does not exist, which is ultimately what TBN did. They created a version of Wise for which no evidence in the record exists that Wise was arrogant or narcissistic. We are not asking the court to delve into what the interpretations of a reasonable viewer are. We are arguing that this version of Wise simply does not exist. And TBN had the responsibility that is no longer, my apologies. Once TBN made that falsehood of him, they lost protection from the First Amendment. The First Amendment flat out does not protect calculated falsehoods, which we believe happened here. And
What case do you cite for that proposition?
in Masson versus New Yorker magazine, there the plaintiff made the statements that he had the wrong man, that he was no longer the honorable person to do that, which goes to the intent of the speaker's words. So there, the Supreme Court found that there was falsity there because the editor of that magazine calculated by making statements that the editor simply had not made in that context and published it for pecuniary gain.
But in Masson, they still published different, the way it came out was different than how he actually said it. And they talked a lot about quotation marks as well in that case. Here, he admitted at deposition, he said exactly that, going to Justice Timmer's point. So once again, what was false? In deposition, he said all of those things.
Your Honor, we ought to look at the statement in its entirety. 80% of Wise's statement was removed, and I believe that a reasonable jury should be able to decide whether that is materially altering. In the case of Masson, they felt that it was materially altering because a reasonable viewer of or reader of the magazine would have a different portrayal or view on what the plaintiff had said. Because what was
Wouldn't that put an end to reality TV then? I mean, my understanding of reality TV, they're just filming all the time. And so what you're saying is that, well, then they need to show all of it because they can't start just picking and choosing, which then puts us in a difficult position, or courts, to try to say, all right, did you give enough? That strikes me as an impingement on the First Amendment.
Your Honor, I believe the court ought not to be concerned with a potential limitation that may have on the First Amendment. We don't believe that would happen because, again, I'd like to reiterate, once you have crossed the bounds of editorial discretion, you are no longer protected by the First Amendment. And moreover, in regards to industry standards, I know that opposing counsel will come up in shortly a few minutes and use that as almost a shield or an excuse. But I'd like to argue that industry standards are not an excuse, which is exactly why once you've made that calculated falsehood, as did the defendant in Masson, you are no longer protected by the First Amendment. And
Let's talk about industry standards here for a minute and proving the reckless disregard for truth or falsity. Under New York Times, mere negligence doesn't suffice. We have a record here which shows overwhelming evidence that the producers and the editors were conscientious here. They were very considerate in their deliberations and discussions as to whether the edited version aired was misleading. So explain how the district court erred in granting summary judgment in that respect.
Your Honor, in regards to the industry standards, we ought to look at Solano versus Playgirl, decided in 2002 by the U.S. Court of Appeals for the Ninth Circuit, where there, the pecuniary gain, in addition to the bad faith that the client exemplified, was enough to warrant a finding of actual malice because they entertained serious doubts. In regards to your industry standards, I'd actually like to refer the court to the record on page 33, where longstanding editor Ramirez, who admits that he had worked on the show for various seasons beforehand and worked on the TBN network in general for many years, expressed doubts. If you have been in this game for this long, as a veteran of the reality TV show network, and you even doubt for a second, having that much experience, that what you're doing is pushing ethical bounds, I believe that question ought to be reserved to the jury. And I agree with you that negligence is not the standard. However, I'd like to establish the negligence there. The fact that you doubted it and continued to move forward would establish negligence. And in addition to that, their profit motive, I believe, raises that to the level of serious doubts required for actual malice.
Don't we want to encourage editors and publishers to have some doubt, to hold back, stop and think, should we be doing this? Is this too far? What is the line? And engage in that discussion. And if we adopt your argument and write an opinion that says that, won't we be discouraging that kind of frank discourse that we want, I assume?
Your Honor, I believe that ultimately the media defendants would have, when they are faced with these doubts, they ought to make some effort to confirm. In Kalin versus Globe Communications Corporation, decided in 2002 by the United States Court of Appeals for the Ninth District, the court there decided that there could be a finding of actual malice because the defendant made no effort to confirm that what they were airing was true.
But this is true, and they know it was true, and they know the whole context. So they're not needing to confirm the accuracy. They're simply considering, all right, in our editing process, are we substantially changing things in a meaningful way? Correct? So isn't that different?
I don't believe that it's necessarily different, Your Honor. I believe the inference that comes from the Kalin case is that you, when facing doubts, The only way you can squash those doubts and thus be protected by the First Amendment is if you make an effort, an external effort, to confirm that your doubts are not enough to warrant a legal issue of material fact. And I believe a
What would they
jury,
do here? How would they confirm with externally confirm? What should they have done?
I believe they could have, whether it be speak to Wise, well, that's not the only option. They could have reached out to other people in the industry, as the defendant in Kalen should have done. Maybe reach out to other people familiar with the matter that they are editing. And I'd like to emphasize that when it comes to those serious doubts, they proceeded in the face of them and made no effort at all. There was a clear statement that Wise had said, prefaced with wanting to help the kids, ending with wanting to help the kids. I'd like to direct the court's attention to, on the record, page 42 and 40, where you can see that not only was the beginning of his sentence cut off, they added a period where it didn't belong. There's clearly some intention there to create a version of Wise that doesn't exist, which brings me back to my first point as to falsity, that a reasonable jury ought to be able to decide, maybe TBN did act with falsity. Maybe they did act with actual malice. Of course, we believe that they did. That question should be reserved to the jury, Your Honor. And I believe the fact that there is enough for us to have this conversation is enough to warrant that there is at least one genuine issue of material fact as to both of the issues at hand.
But isn't this false light akin to defamation? It is. And so if it is, and truth is a defense, and he admits that everything they broadcast is true, how do we not affirm summary judgment under Mayweather, the Mayweather case?
In Jackson versus Mayweather, the reason that there could not have been a different effect on the mind of the reader is because the plaintiff's having of plastic surgery was undisputed. Wise's goal was undisputed for fame. But it was the fact that they had any plastic surgery would have been disqualifying regardless. So they could not have proven that there would be a different effect on the mind of the reader. Yet on page 23 of the record, Wise's own family could not recognize the person that they have known for such a long time. He received letters, emails from colleagues that said, you are not the altruistic person that we believed you were. And if there was any ambiguity to have been found, maybe TBN would be within their First Amendment protection, but they deliberately created a version that Wise that does not exist, evidenced by the reactions in his family, the reaction of his colleagues, and because of that, we ask the jury to not find that there is falsity or that there is actual malice, but that a jury ought to be able to decide, given the existing case law within the Ninth Circuit. And furthermore, TBN's profit motives and the fact that they disregarded, sorry, Your Honor, I see my time is up. May I conclude my point?
Yes, you may.
Coupled with their profit motives and their blatant disregard for their ethical boundaries, I think that is enough to warrant whether a jury ought to decide if that rose to the level of serious doubts, which we believe it did. Thank you so much, Your Honor.
Thank you so much. All right, we're going to hear now from the appellee, which is the Bear Network. And you can proceed whenever you'd like.
Thank you. Good afternoon, Chief Justice and Associate Justices, and may it please the court. My name is Wasal Esper, and I represent the appellee, the Bear Network, in this matter. Your Honors, the First Amendment safeguards the freedom of the press as a cornerstone of our democracy. This court should affirm the lower court's grant of TBN's motion for summary judgment for two reasons. First, TBN's broadcast of Jet Wise was substantially true. And second, TBN did not act with actual malice in publishing that broadcast.
Well, I want to get right to this question, which is, given the record before us, in this court's determination that a publication conveys a defamatory meaning, we said in Solano that not only do we look at what is explicitly said, but we also look at what insinuation and implication that can be reasonably drawn from the publication. We look at both, not just what's explicitly said. So therefore, shouldn't the district court be reversed? Because it only, in its order, looked at explicitly what was said under Matchletter, which, by the way, is a Second Circuit, not our court.
Absolutely, Your Honor. The reason why when looking at what was said and what could be inferred from what was said from Jet Wise's statements, both statements resonate with an audience that he wanted fame. One was a little bit more favorable simply because there was a reason why he wanted that fame. But either way, both statements indicated a want for fame, so there was no material change in what Jet Wise was saying through the publication of the footage. Therefore, there was no change, and he wanted to be famous either way. It's within TBN's editorial discretion and First Amendment protections, frankly, that they're able to edit those things out because there's no requirement on the media to favorably paint everybody that they
Well, do you
show.
agree that by not including his altruistic motive as far as why he wanted to be famous, that it created the natural reading of that is that he just wanted fame and fortune and et cetera? Do you agree that that was the natural implication of his words as shown?
Respectfully, Your Honor, both statements would have resonated as a want for fame. One had a little bit more context, but the court has found that that's okay because this case here, the TBN case, is distinguished from cases such as Price v. Stossel and the Masson v. New Yorker magazine that opposing counsel brought up to the court because in the Price v. Stossel case, there was a material change in what was said. So it went from the preacher speaking from the perspective of a hypothetical man to the preacher speaking about himself. And even though the preacher was rich, he never boasted about his wealth. So the edit was there and used to show that he was boasting about his wealth, which is something he never did.
Well, is it a material alteration to change something from saying, I want to be famous to help the deaf child community versus I want to be rich to feather my own nest, for lack of a better term?
Your Honor, the I want to be famous or fame will get me what I want and to help the deaf kids statement, both I want to be famous and I want to be famous to help the deaf kids both mean that he wanted to be famous. He wanted fame in both instances, and TBN believes that it is within their editorial discretion to take out those favorable facts, which is within the limits of the First Amendment.
Well, does it make a difference to say, if someone was quoting Robin Hood, I want to take from the rich, but then what about give to the poor? Left out?
Your Honor, that is the same situation here where it would be fine to omit that because that's just a mere favorable fact. Robin Hood still took from the rich. So what is resonating there, the factual basis of what he's saying still is, I want to be famous or I take from the rich. It didn't change the fact, there was no material change in what Robin Hood's doing just by adding favorable facts of him giving to the poor.
But doesn't Solano instruct that we must view statements in context? And when you look at the context, how was the editing not creating a false impression? It may have been factual, he made those statements, but is it really TBN's argument that you did not create a false impression about what he was saying?
Your Honor, what TBN is arguing is that there was no material change in what he was saying. The TBN should not be held accountable for what it is that Jet Wise is saying on a reality television show. So yes.
How is that not a question of a genuine issue of material fact as to whether or not there was a material change? I mean, going from I want to have fame to help the deaf community, the deaf youth community, to I want fame to feather my own nest are really different contexts, wouldn't you say?
Your Honor, the reason the trial court did not err in their grant for summary judgment is because he wanted fame. Jet Wise simply wanted fame and came on the show, and TBN erred that Jet Wise wanted fame. So both statements are true in that case. So there was no material change, and there wasn't a falsity piece because of that. But further, even if the court decides that there was material change or there was falsity, they still needed to find, as a matter of law, that there was actual malice with the clear and convincing evidence piece as well. So moving to my second point of actual malice.
Well, before you move to that, if we disagree with you and find that an issue of material fact on falsity. Do we even need to address malice?
Absolutely, Your Honor, because this is an elemental test, and there is a public interest in resolving free speech issues quickly and promptly through the courts, and we don't want to task the court with having to adjudicate every single edit within reality television.
Well, let me ask you, the network needed better ratings right away and said that, quote, reality TV is all about the drama. They believe that this version pushed ethical boundaries. Why isn't that reckless disregard as to the truth or falsity as well under Solano?
Absolutely, Your Honor. The reason why pushing ethical boundaries and crossing editorial boundaries, they're two different things and they're two very distinct things. Opposing counsel mentioned doubt and how there was doubt in this case. And yes, there was doubt within TBN's editorial room. However, those doubts were addressed in comparison and distinguishing from the Solano v. Playgirl case, because in Solano, the doubts were completely brushed off, and the editor was quoted saying, "We definitely weren't trying to be subtle and we knew it," and there was they rose to the level of knowledge there, whereas the facts here don't rise to the level of knowledge through the clear and convincing evidence, because Denzel Williams at the record at 49 acknowledged Kumar's concerns, which was the editor who came and brought up these concerns, that it could change the meaning, but not that it would.
Let me ask you again in Solano, and this is our court, we said the subjective determination of whether the defendant had serious doubts as to the truth of the statement may be proved by inferences, because it's rare, like here, that a defendant's going to admit such doubts. So the court should infer actual malice from objective facts. So isn't there conflicting evidence here in the record, clearly conflicting evidence from the objective facts supporting actual malice, such that there was triable issues of material fact for the jury?
Your Honor, respectfully, I don't believe that, because of the fact that the entire record, when looking at the editorial meeting, these concerns were addressed as a whole. And Denzel Williams not only thanked Sanjay for her concerns, but Denzel Williams, an executive producer of 8 years, was convinced that they did not need to worry about any kind of misrepresentation, because there were no voiceovers or alterations, and they were acting within industry standard in that case. So whether or not they knew is what goes to prove actual malice, and they didn't know, because all four of them, they were the experts in this case. They have enough authority. There was no one else they needed to go see, because there were 24 hours of footage of Jet Wise that they have to review over and over again.
Which case holds that industry standards is relevant to the issue of actual malice?
Your Honor, the industry standard being relevant goes to speak to the knowingly and recklessly disregarding the truth
Is there a
element.
case that says that that is a criteria that we should consider, this court should consider in determining whether or not actual malice exists?
No, Your Honor. However, in the Kalin v. Globe Communications Corporation case decided by this court in 1998, a public figure in a defamation case can't recover unless they prove by the clear and convincing evidence that the defendant published the statement with that actual malice. And actual malice would be the knowingly and recklessly disregarding the truth. And here they're not disregarding anything. They're having doubts, which are healthy, as seen in the Jackson v. Paramount case. But doubt here is good. We want to encourage them to have this doubt, but the industry standard goes to speak to their state of mind of what it was that they were believing that they were operating under.
If we start considering industry standards, won't it just be a race to the bottom?
No, Your Honor, I don't believe so, because the industry standard, so I'm not asking the court to allow industry standards to legislate. However, I am asking the court to allow the First Amendment to protect media companies and the freedom of the press. An industry standard is within the bounds of the law. It's not its own law. In this case, so the industry standard just went to go, or to speak to Mateo Ramirez's 11 years of doing this, and he has always acted within the bounds of the law in this case, and he was able to inform all 4 people in this meeting that what they were doing was fine. They didn't have any alterations, voiceovers to make that material change, and they all believed that they raised a concern, they discussed the concern, and then they moved on from that concern, which is distinguished from the Solano case where the doubts were completely brushed off.
How do you respond to opposing counsel's argument that, that the publishers and the editors should have conferred with external sources to confirm that what they were doing was correct?
Absolutely, Your Honor. TBN does not believe that they need to confer with external sources beyond the company. They did confer with one another, and they're all experts in their field. We had the assistant editor, the executive producer, the producer, and the senior editor all at this meeting. They were not merely just low-level employees at TBN. They did go and confer with the experts within their field, within the entire network, not at the Bear Network. Further, this case is similar to the Jackson v. Paramount case, which is persuasive authority. However, the facts are fairly similar, where the doubt there was not enough, where there was doubt about the X-rated videotape, whether it was out there, the 27-minute tape. However, there was only doubt. There was not knowledge that it wasn't there. There was enough context to allow for that, and here, there's enough context to allow TBN to reasonably infer that Jetwise wanted fame. He came onto the show and he said he wanted fame, and that's all that they
But
showed.
in Jackson, I mean, that was talking in terms of need to ferret out the truth, that they needed to do there. Here, you knew the truth, or your client did. There was no doubt about what was said, the context in which it was said, along with the context of what the other 2 participants in the conversation were also saying. So the choices here were deliberate to make it good TV. So isn't that distinguishable from Jackson in terms of the expressing the doubts? I mean, is it really the same type of case that you can rely on?
Your Honor, the reason it's not distinguishable is because those facts and additions were just favorable facts. It was okay for them to omit it, and TBN knew that Jetwise wanted to be famous because Jetwise said he wanted to be famous. So he was answering a question to other contestants on the show, talking about why he joined the show. And he joined a reality television show to gain fame and use it as a medium for fame for his nonprofit and community. However, he still wanted fame at the end of the day.
But how do you reconcile what your counsel said on the other side of the aisle? I mean, isn't it true, just like Mason, your client deliberately altered the words uttered by Weiss, resulting in the material change in the meaning conveyed by his statement? That proves deliberate and reckless falsification in this case under Mason. And you heard from counsel on the other side of the aisle say his friends and family didn't even recognize it's the same person. So how is that not a material change?
Your Honor, it's not a material change because in Mason, the meaning went from I'm the wrong man to stay silent just to take a bribe and get my job back to I am the wrong man to do the honorable thing, which is the complete opposite of what he was saying. And it is critical that this court affirm the lower court's ruling because restricting editorial discretion would lead to a climate of self-censorship whenever a media organization is publishing anything for fear of getting involved in litigation. So for the reasons stated, I respectfully ask the court to protect the First Amendment as a cornerstone of our democracy by affirming the trial court's grant of TBN's motion for summary judgment.
Thank you very much.
Yeah.
All right, well, 1 minute now on rebuttal. We'll hear from appellant whenever you're ready.
Thank you. Opposing counsel mentioned that there was hundreds of hours of footage for TBN to sift through, and we believe that's not an excuse. We are concerned with one clip. We are also not concerned with whether Wise was portrayed in an unfavorable light. We are concerned with the fact that he was portrayed in a version of him that does not exist. Wise's purpose for saying that statement was because he wanted to help the kids. That statement was inseparable, thus raising a genuine issue of material fact as to falsity. And once they separated, those 6 words that were not a burden to have added, when they blatantly disregard just adding a few more words for that needed context, raised a genuine issue as to actual malice as well. Coupled with their pecuniary gain, with their ultimate mission of creating a villain that did not exist, we plead with the court to allow a jury, a reasonable jury, to decide whether a genuine issue of fact, whether falsity or actual malice exists. Thank you so much.
Thank you very much. This matter now stands submitted with the court, and at this time, I'd like to thank everyone, and we'll be in recess. Thank you very much.
All rise. Congratulations to both of them.
That'd be great.
Thank you.
Okay. If you guys, if we can just flip those down.